protection under the law. It sounds simple, but for most of American history, the Equal Protection Clause was more like a promise delayed than a promise delivered. Let's talk about it. No state shall deny to any person within its jurisdiction the equal protection of the laws. Sounds straightforward. The Equal Protection Clause is part of the 14th Amendment, passed in 1868. It was supposed to ensure that Black Americans, specifically newly freed enslaved Americans, were treated equally under the law. But here's the problem. Just because something is written in the Constitution doesn't mean people actually follow it, and white lawmakers and judges spent decades finding ways to ignore or weaken it. Not long after the 14th Amendment was ratified, the Supreme Court basically gutted its power. In the Slaughterhouse Cases, decided in 1873, the court ruled that equal protection only applied to federal laws and not state laws. A group of white French butchers sued the state of Louisiana for creating a monopoly in the butcher business. Among other legal arguments, the butchers believed that the state action violated their 14th Amendment, their right to equal protection. The Supreme Court disagreed. For the first time, the court made it specific that the 14th Amendment only applied to freed slaves. Sounds decent, right? Well, its impact wasn't so pleasant. The states used this ruling to justify the creation of discriminatory laws, arguing that equal protection only applied to actions of the federal government. Each state could have the choice to discriminate or not discriminate, and the feds couldn't say much about it. This paved the way for Jim Crow and separate but equal policies, and this ruling's effects lasted over a century. And it got even worse in Plessy versus Ferguson. Remember last week's lecture? This case upheld racial segregation, saying that as long as segregated facilities were equal, they didn't violate the Equal Protection Clause. But as we know, they were never truly equal. And this ruling gave birth to Jim Crow, keeping Black Americans legally segregated and disenfranchised for nearly 60 years. But here's the thing. Black lawyers weren't just sitting back and accepting this. Legal giants like Charles Hamilton Houston and Thurgood Marshall developed a strategy to use the Equal Protection Clause against segregation, starting with education. And in 1954, they won. In Brown v. Board of Education, the Supreme Court finally admitted what Black Americans already knew: separate is never equal. This decision overturned Plessy, ruling that racial segregation in schools violated the Equal Protection Clause. It was a massive victory for the civil rights movement. Now, just because something is ruled unconstitutional doesn't mean it disappears overnight. And let's be honest, just because the Equal Protection Clause exists doesn't mean it's always enforced fairly. In 1965, the Voting Rights Act was passed to protect Black voters in states with a history of discrimination. One key part of the law required certain states and counties, which were mostly in the South, to get federal approval before changing their voting laws. That meant states like Alabama or Georgia couldn't suddenly pass new voter restrictions without proving they weren't discriminatory. But in 2013, the Supreme Court struck that down in Shelby County v. Holder. The court ruled that times had changed and states shouldn't need federal approval anymore. And almost immediately, states started passing new voter ID laws, closing polling places in Black neighborhoods, and purging voter rolls, all of which disproportionately affected Black and Latino voters. So yeah, equal protection in voting is still very much up for debate. Now let's talk about affirmative action, one of the biggest Equal Protection Clause debates in recent years. For decades, colleges used race-conscious admissions to help Black and Latino students overcome systemic barriers in education. But in 2023, the Supreme Court ruled in Students for Fair Admissions versus Harvard that using race as a factor in college admissions violates the Equal Protection Clause. The case was brought by a conservative group arguing that Asian American students were being discriminated against in Harvard's admissions process. The Supreme Court agreed, saying that race-conscious admissions are unconstitutional, essentially ending affirmative action at most colleges. So what does this mean? Colleges are now looking for new ways to maintain diversity, like focusing on socioeconomic background instead of race. But many experts worry that this decision will reduce Black and Latino enrollment at top schools. And we already see its effects. According to the New York Times and the American Bar Association, Harvard Law enrolled 19 first-year Black law students, or 3.4% of the class, the lowest number since the 1960s and since the Supreme Court's decision. So now I have a question for you. Is the Equal Protection Clause being applied fairly today? Make sure to vote in the poll and then drop a comment explaining your vote. What's one issue where you think the Equal Protection Clause is either working or failing?